counsel is present. Ma'am, you signed what's called an advice of rights form at the jail. I'm holding it up right now. Do you have any questions about any of these rights?
No.
All right, I'm going to pause briefly. The APA has logged in, so the assistant prosecuting attorney is present. I'm going to, I do have APA Andrew McGarrow present. We did start the arraignment. We're just going over rights at this point, counselor. We did start because all the parties were present. I do have the officer in charge as well as pretrial services present in my court. Could you state your name for the record, please, Mr. McGarrow?
Yeah, Andrew McGarrow, appearing on behalf of people, Your Honor.
Thank you. All right. So again, just to update you where we're at, I'm in the process of going over her rights, but we went over contact information. She waived formal reading, rendering not guilty plea. For your record, counsel, the probable cause conference is set for February 9th at 8:30 for Judge Karniak. And if she chooses, Ms. Hernandez chooses to have an exam, it's set for February 17th at 8:30 for Judge Karniak. Again, I believe the PCC will be via Zoom. All right. So, Ms. Hernandez, as I mentioned, I'm holding up an advice of rights form that you signed and dated at the jail. Do you have any questions about any of these rights?
No.
The key rights on here are your right to remain silent. Anything you say could be used against you. You have a right to I'm recording this. You have a right to an attorney. If you couldn't afford one could be appointed for you. And you have a right to a trial by judge or jury where you're presumed innocent. The burden of proof is on the prosecutor. You have the ability to call, see, hear, question witnesses. You could be a witness in this case, but if you chose not to, it wouldn't be held against you. Do you understand those critical rights?
Yes.
I'm looking at your request for court-appointed counsel. I'll be honest, counselor, based on the information she included in here, it's not likely that I'd approve court-appointed counsel. She indicates that she makes $1,900 a week, and then she owns two 2020 Jeep Cherokees. She has a bank account, a PNC bank account. She has a home that she owns, and the value is $115,000. So I'm not sure.
My mom owns.
Ma'am, please go ahead.
My mom owns that house.
Okay, so that is.
I didn't. That's like.
I'm going to know in the file that's owned by your mother. Are you able to continue these positions that you have, or are you going to lose employment during this time? Do you anticipate, ma'am?
I might lose at least one of them. The two jobs that I do have, the second one, I don't start until this weekend because I just got it. The third one wouldn't even be starting until end of February.
Okay.
So I only have one job right now.
You just have
which
one
is like
job. And how much do
$1,500.
you make every week in that one job?
Like 1,100, sometimes a little bit more because it's serving.
All right. Based on the seriousness of the charges, as well as that additional information about the home, I do think that you're eligible for court-appointed counsel. I will sign off on this. So we'll have court-appointed counsel present to assist you in this matter, ma'am. All right.
Thank you.
So we have gone over your charges. We've gone over your rights. We've gone over request for court-appointed counsel, which I did just approve. The last piece we need to talk about today is about bond. The point of bond is protect our community and make sure you come back to court. Those are the two areas that I'm really focused on. So I'm going to focus, I'm going to hear first from pretrial services. Mr. McGarrow, do you want to address bond?
I will, Your Honor, yes.
Okay, and OIC Detective Conley's present as well. I'm not sure if you two will both address bond, but they may. So what I'll do is I'm going to hear from Ms. Finley from pretrial services. Then I'll hear from Mr. McGarrow and or Detective Conley, and then I will hear from your attorney, ma'am, and then I'll set bond. Please go ahead, Ms. Finley.
Darla Finley, pretrial services. The defendant was interviewed, background information was verified. She is 34 years old, married. She does have a 4-year-old child that she has full custody of. She is living with her mother at the Filomeno Boulevard address in Lincoln Park for the last, she stated 10 years. And speaking with her mom, though, she's only been there for the past year consistently. Prior to that, she was living in Texas with her husband for 8 to 9 months. She does report the full employment as a server in Royal Oak for the past 4 months. She last worked on the 24th. She stated that she has completed her GED. She also did mention that she has other employment lined up as a bartender and server that she's supposed to start in the near future. She did report the use of alcohol use. Last used alcohol 3 years ago, first tried it when she was 21. No prior substance abuse treatment, no health concerns or prescribed medications currently. She does have another hold out of the 25th District Court. She's not currently on probation or parole. She was last discharged from probation on 11/20 of 2023. She has previous assaultive contacts involving violence. However, she has no prior convictions for assault on her record, no history of failing to appear. The alleged incident or the incident involved a homicide located in Rochester Hills. The alleged victim's wife was present during the alleged incident. There were, according to Clemens, no prior police contacts between the defendant or the listed alleged victims in this matter. They appear to all be strangers. She does have 2 co-defendants in this matter. Given she has a verified release address, strong ties to the community, she is gainfully employed. Although she is facing serious allegations and has connections to other states, there are conditions of release that can help mitigate and ensure public safety and her appearance. We are recommending release with pretrial supervision, a GPS tether prior to her release, only to leave her home for verified employment, verified medical appointments, attorney visits, and court dates, that she not possess a firearm or dangerous weapon, no assaultive contact with anyone, no contact with alleged victims or any of her co-defendants, that she not have go to the Newcastle address in Rochester Hills.
Thank you, Ms. Finley. Ms. Magaro, please go ahead.
Yes, Your Honor. I handled the case with the co-defendants through trial back in September, October. I know Ms. Hernandez does not have a lengthy criminal history. However, the facts of this case are quite serious. The charges themselves are quite serious. I believe she is intimately involved with the planning and preparation of this of the homicide that occurred last year. And she also was intimately involved with helping her husband leave the state of Michigan and avoid criminal charges here. One of the factors that this court is to look at when determining bond is the likelihood of conviction and the possibility of a prison sentence. I have calculated the guidelines of 84 to 140 months as charged in this case, Your Honor. I believe a high cash bond is necessary to protect the safety and community and to ensure that she remains in the state of Michigan, because over a year ago, when this case happened, she was involved with transporting her husband back to the state of Texas. They were picked up in the state of Louisiana. I believe, ensure her appearance in next court dates, I believe a high cash bond is absolutely necessary.
When you say high cash bond, what do you mean by that?
And a minimum of $100,000 cash, Your Honor. No 10%.
Thank you. Judge Conley?
Yes, ma'am. Through this investigation, substantial evidence has been obtained. Shows that Amanda had knowledge of the crimes. She helped facilitate the planning of the crimes, helped facilitate the crimes themselves, as well as the attempted escape following the commission of this crime. This department's also obtained information of a failed to appear history out of Lincoln Park. Mrs. Hernandez also has ties out of state, specifically Florida and Texas. Through this investigation of this matter, evidence has been obtained that clearly shows Mrs. Hernandez immediately fled the state with the co-defendant, Carlos Hernandez, on their way back to Texas. They were stopped in Louisiana. That's where Carlos was taken into custody. There was a nationwide be on the lookout for them that was put out at that time. They were stopped in Louisiana. Due to these reasons, I have reason to believe that Ms. Hernandez could possibly be at flight risk and that her return to court in this matter is not guaranteed. And that's why I'm asking this court to put in bond conditions that would secure that interest. I'm requesting the court consider a $100,000 cash bond, no 10% provisions, as well as a GPS tether upon release. I further request that this court place a no contact order with the victim, any of the victim's family, as well as your 2 co-defendants, Carlos Hernandez and Joshua Zuazo.
Thank you. Counselor?
Yes, Your Honor. So the information provided by pretrial services is correct. I did just want to, before I go into the bond factors, address some of the things that the detective was saying. Ms. Hernandez was not a co-defendant when there was a warrant issued for her husband. So to say that she fled the state, she was not under any obligation to remain in the state. She is, a resident of the state of Michigan, and she has a stable residence. She's employed. She doesn't have any prior criminal convictions. So having no prior criminal convictions, I don't know how we can, articulate that she has a history of failure to appear because she doesn't have any convictions. The charge that she's charged with. So just, to I guess mention the statutes and the law a little bit. A defendant, most defendants pre-trial are entitled to a reasonable bond. That's both a constitutional and a statutory right. And I want to point the court to People versus Decaloni, which is 16 Mishap 352 MCL 765.6 and MCR 6.106. You can, for sure not deny bond in this case. In addition to that, if we look to what a reasonable bond should look like for Ms. Hernandez, according to MCR 6.106C, Ms. Hernandez should, as it's recommended by pretrial services, be placed on a personal bond. She doesn't meet the criteria of MCR 6.106 B or E, or B, which is a bond denial, and subsection E, which is a monetary bail. She is charged with a violent offense per statute, the home invasion first degree, but she's not a flight risk. And if the court was to place her on a tether, she wouldn't be any danger to the community at large. I think everybody's very well aware that Ms. Hernandez was not physically present when the crimes that the co-defendants were ultimately convicted of were committed. She's not charged with homicide. She's charged with under what would be a conspiracy theory of home invasion first degree and some 2 5-year felonies along with that. So therefore it should be a personal bond with conditions. I don't think that the tether requirement is unreasonable, but she doesn't meet any of the factors under the statute for providing her with a monetary bail. I know the prosecutor mentioned the high likelihood of conviction, but there is also a slew of other conditions, ties to the community, employment history. She has family. There's no history of substance abuse or mental illness. She has a stable residence, family support, 3 jobs, 2 of which she's scheduled to commence soon. And, quite frankly, she's been in the state of Michigan even throughout the time that her husband went through trial, was convicted, and has been sentenced. She didn't go anywhere. So I do believe that both the 8th Amendment to the United States Constitution and also Article 1, Paragraph 16 of the Michigan Constitution demand that you provide her with a personal bond with, whatever other reasonable conditions you deem appropriate. So that's my request.
Thank you. Again, my focus is, are you a danger to our community when you come back to court? And when I'm looking at the factors, I agree with your counsel that you personally weren't fleeing the state, but the allegations are that you assisted your husband, who was a suspect at that point in a homicide, to leaving the state. So I agree. And yes, you might not have a history of failing to appear in that you didn't have criminal offenses, but there is an open warrant for you out of the 25th District Court. So I'm saying that you failed to appear in that case. And we have a situation here where the allegations here, the seriousness of this offense is significant. The allegations are you conspired to commit a home invasion in the first degree. That's a very serious violent charge. Allegedly, the second is that you're accessory after the fact of a felony, and that felony, again, is serious both in its violent nature, the potential consequences, and then a conspiracy to commit false impersonation of a public utility worker. And again, that all ties into the allegations that you were part of this larger scheme that resulted in someone losing his life. Okay, so the seriousness of the offense charge is significant to me. Protection of the public is concerning when there's allegations of violence. And when I look at your criminal record, I agree that it's not significant. But the factor that weighs very heavily for me is the probability of you appearing in trial. Okay, that concerns me, that allegedly you identified an issue with your husband and assisted and were with him as he fled the state. Okay, to me that shows knowledge of something and your choice to leave the state to try to escape prosecution, your husband's prosecution. So I'm concerned about that. Huge factor to me, seriousness of the alleged offense and that fleeing, okay, alleged fleeing with your husband, you were not charged, and I agree with your counsel on that, but you assisted him in fleeing when these charges were pending clearly. So I'm concerned. I don't believe a personal bond. I disagree with pretrial services. I disagree with your attorney. I do believe under the court rule and under the factors I'm to assess based on the information received from pretrial services and my analysis of the case that a personal bond is not appropriate in this case and will not protect the community and will not ensure that you'll come back to court. So I'm going to order that you, your family, friends, or agents will have no contact by any means. That's personal, not just personal contact, but contact by mail, telephone, or electronic equipment with Linda Murray and her family. You're not to return to the premises known as 3730 Newcastle Drive in Rochester Hills. You shall not possess or have in your place of residence any firearms or other dangerous weapons. No assaultive behavior towards anyone. You'll be supervised by pretrial supervision. You must contact them by the next business day after your release, okay? You, before being released from county jail, you shall wear and pay for a GPS tether. And I believe a tether is appropriate, again, because of my concern about you fleeing. You have out-of-state contacts in Texas while you were picked up in Louisiana and then Florida. So again, I'm concerned about you not being here. So while on tether, you may leave the home for medical appointments, court appearances, verified employment, and attorney visits. You shall appear for all appearances and notify the court in writing of any change of address or phone number. You shall not leave the state of Michigan without permission of the courts or violate any local, state, or federal laws. I'm also ordering no contact with Carlos Hussein Hernandez or Joshua Zuazo. The two individuals were convicted of the underlying murder, I believe, in this case. And this order will be entered in the lien system, so all police agencies will know where you're not supposed to be and with whom you're not supposed to have contact. Do you understand those bond conditions, ma'am?
Yes, ma'am.
And as I indicated, I don't believe a personal bond is appropriate based on the facts presented and the information presented today. So I do agree $100,000 cash surety bond, no 10% is appropriate in this case. You'll have an opportunity to, again, address bond when you go before the judge for your probable cause conference. But based on the information I have today and my concern about you coming back to court and because of the seriousness of these offenses, you can address it with Judge Karniak on February 9th at 8:30, but your bond is set at $100,000 cash surety, no 10% with those bond conditions. Do you have any questions for me, ma'am?
No.
Is that a yes or no, ma'am?
No.
Okay. Counselor, Mrs. Bunzo, you're muted.
Yep. I was just saying, she said no. She was just soft-spoken.
Okay. All right.
Sorry.
Thank you. All right. This concludes your case, ma'am. Wish you the best of luck. We'll see you on February 9th at 8:30 for Judge Karniak. I believe that'll be via Zoom, but look at your paperwork. Thank you for logging on, Ms. McGarrett, as well. And thank you for being here to talk.
Thank you, Your Honor. Appreciate it. Thank you.
Thank you, Anna.
So, ma'am, you can just open the door and let the deputies know you're done, okay?
Okay. Am I allowed to talk to my attorney?
I'm not at this time. That would be a separate time. You're going to be appointed a new attorney. She was here for your arraignment only, okay?
Okay,
She could be your
thank you.
attorney, but I don't know. All right.
Okay.
Thank you.
Thank you so much.